of a last will and testament. And while it does consist of a last will and testament, there's really a whole lot more to it than just the last will and testament. So things that we looked at with Herschel and Nell, and this is in your slides. I'm not going to mess with the big getting the slides up here for this. No, it's okay, really. I'm only 5 minutes on this. But I will bring the slides up for the second half. So we talked about creating wills, doing some trust planning. You heard them talk about their son, Ted, who's not really that great with money, so we were able to put in place some trust planning for him. As we embarked upon estate planning, it's important to figure out how are your assets titled in the first place, and to understand what is it that your will is even going to control. So it's important to go through and determine what things are going to pass by operation of law, what things have beneficiary designations, and to understand really what this beautiful will that you're putting in place is actually going to control. Then also, we had a conversation about planning for incapacity, which is a time when a person is no longer able to manage his or her finances on their own. And so that type of planning is dealing with powers of attorney. So there are two powers of attorney that you want to look at. One is a financial power of attorney, which is naming someone to handle your finances for you, to interact with your CPA and get those taxes done. That's one side of the financial planning arena under powers of attorney. Then we also need to plan on the medical side of things. In Georgia, we have a durable advance directive for health care. Everyone should have one of those in place. Up until 2007, it was a living will and a durable medical power of attorney. As of 2007, the Georgia legislature rewrote our statute. We now have those two documents combined into one. So within one document, you're saying, here's the agent that I named to make my healthcare decisions, and then also here are my wishes with regard to end-of-life decision-making. A lot of people tend to think, oh, I need a living will, I need a living will, I need a living will, and that's true, but it's also important to realize living will is strictly end-of-life decision-making. There's a lot of middle ground between perfectly fine and end-of-life, and that's where you want to have an agent designated to make decisions for you. So we looked at getting these powers of attorney in place for Herschel and Nell, and we did. These power of attorneys were immediately effective. That's another point where I tend to get on my soapbox in this discussion, is that when you have a power of attorney, there's an option of having a power of attorney that is what's known as a springing power of attorney. It springs into effect upon some contingency. That might be your primary physician saying, okay, Heather can't handle her affairs anymore, activate that power of attorney document. Or it might say, 2 of my 3 children agree. That can be even worse, right? Dealing with families? Yeah. So it's always my recommendation that a power of attorney be immediately effective, because then you're not having to look in a time of crisis to getting the formalities taken care of to bring this power of attorney into effect. Also, people will tend to say, well, gosh, I don't want them to have the authority to handle my stuff right now, because that's what an immediately effective power of attorney does. So I don't want them to have that power right now, and then I look at that as a gut check for the client. If you're not okay with naming this person to handle your finances right now, and you're perfectly capable of watching every step they do you really want them handling them down the road when you have no idea what's going on? You know, especially like if you had dementia.